Fuck is poppin'. If you try to run off, you know we popped your name. First you get that money, then you get that power. If he tuned in, knows up, but he on that powder. Now you walk around with 50 in your trousers. Diamonds bullying on my chest, my fucking blouse. Bitch, I make it rain shower. You did that. Ain't wanna know a thing about you, you can seal that. Hit him with that blocker, nigga, get back. Feed that bitch that never crack, get that shit.
Hey y'all, I'm here. Let's see. So shout out to Bree. Brian Steele filed a motion last night to recuse Judge Glanville. So let's see if we can read through it. Let's see. Let's look at the comments. Let's see who's here. Hey y'all. Hey Bree. Hey B. Hey Mel. Hey Nurse, Sierra, Kiki, Lee. All right, let's see if I can get the motion up. And it's 233 pages, which is absolutely insane. Let's see. Let's check it out and see. Try to finally plan her ex if she really think Joe gonna make if she keep cooning, she might, but I highly doubt it. I don't know, y'all. I feel Fonnie thinks she got a chance with something. I don't know what just yet, though. Okay, let's pull up this motion. Let's see if I can share it. Motion to recuse. Alrighty, let's see. All right, can y'all see it? Okay. She said most of it is exhibits and transcripts. So Brian still said he is not done yet. He said he is coming and taking everything they thought they had. He is not fooling with them. Let's see. So we have a supplement motion to recuse Judge Glanville. So it says, comes now Mr. Jeffrey Williams by and through undersigned counsel hereby timely files this supplement to motion to recuse Judge Glanville in the above referenced case. In support of this motion, Mr. Williams shows as follows. This supplement to motion to recuse Judge Glanville as well as the attached joint affidavit, Exhibit A, is timely filed as Uniform Superior Court Rule 25.1 mandates that the time for filing a motion to recuse shall not be later than 5 days after the affiant first learned of the grounds. So let's see. This motion applies to lawyers Love and Hilton in addition to Judge Glanville, as all three are material witnesses and still ain't playing. Material witnesses in the case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. The motion also timely moves to recuse Honorable Judge Krause based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April 2024, Judge Glanville contributed $2,000 to the Honorable Judge Krause's re-election campaign. Also, in April 2024, the Honorable Judge Krause donated $500 to Judge Glanville's re-election campaign. Mr. Williams' trial has been ongoing since January 4th, 2023, and therefore includes April 2024. That's insane. Let's see. Undersigned counsel derives no happiness when filing this supplemental motion. However, let justice be done through the heavens fall. Actually, the heavens will not fall by unmasking bias and unethical members of the bar. Let's see. This is just going through. Let's see. Thus, this supplement motion to recuse as is timely filed as the addition reasons for the recusal were first learned on Monday, July 1st, 2024, when Judge Glanville permitted the court reporter to release to undersigned counsel the transcript of the Monday, June 10th, 2024 ex parte meeting between Judge Glanville, lawyers Hilton and Love, the Honorable Attorney Bumpus, and her client. Notice he only put honorable in front of Kayla's name. And her client, sworn witness Mr. Kenneth Copeland, and others. This timely filed supplement to motion to recuse has also been timely presented to Honorable Judge Krause and Judge Glanville on Monday, July 8th, 2024. Ooh, still is messy. Still is messy and petty. He letting them folks know he don't fool with it. That is hilarious. Let's see. In the case at bar, Judge Glanville's ex parte communications with the sworn witness, his counsel, lawyers, Love and Hilton, and other representatives with the Fulton County District's Attorney's Office are seemingly only partially captured by the court reporter. Judge Glanville, lawyer Love, and lawyer Hilton have prejudiced and tainted Mr. Williams' trial so deeply as Judge Glanville has not acted as a judge, but morphed into an essential part of the prosecution team. The judge's conduct, including ex parte communication with the prosecutor during trial, resulted in the appearance of bias requiring reversal of the convictions and sentences. Ooh. Partially. That's right, Breach. He said partially. Partially. That means he must got a recording or he know firsthand because he is talking that big boy talk. If Kayla's the only honorable person, it's a Hey, all right. It says USCR 4.1 mandates that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Yet, Judge Glanville participated in these ex parte communications and then somehow attempted to keep the secret by referring to the meeting as privileged and describing the improper secrecy as sacrosanct. Judge Glanville has totally abandoned his role as a judge and has become a prosecutor against Mr. Williams. Boy, who done sat here and gave Steele a shot of Hennessy? Because Steele is coming to all the barbecues when all this over with. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless. Mr. Williams timely raised his objections to these ex parte communications and recusal of Judge Glanville, to wit, when he first learned of same. Not put in the definition of sacrosanct means most sacred or holy. Let's see. Canon 2, Rule 2.9 of the Georgia Code of Judicial Conduct forbids a judge from considering ex parte communications as judges shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard according to law. Judge Glanville embraced his view that the communications at this ex parte hearing were privileged. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of the parties or their lawyers concerning a pending or impending proceeding, except communications for administrative purposes, emergencies, consultations with experts, or court personnel in settlement conferences. Code of Judicial Conduct Rule 2.9a, it is also clear that ex parte communications are presumed to have been in error, and once a party has shown that a judge has received an ex parte communication, there is a presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication. Let's see. In the case at bar, there is not a scintilla of evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications, as captured in Exhibit B, resulted in harm. Thus, Mr. Williams' case should be reversed on direct appeal if there is any conviction and sentence. Let's see. As shown in the joint affidavit attached hereto as Exhibit A, Judge Glanville not only conducted this improper and unethical ex parte meeting, Judge Glanville therein acted as an advocate for the Fulton County District's Attorney's Office as he dispensed legal advice and supported lawyers Hilton and Love's goal to have Mr. Copeland testify against Mr. Williams and the other co-indictees. In light of this ex parte proceeding, it is impossible to conclude that Judge Glanville is impartial and not a member of the prosecution team. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, including cases in which the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the proceedings of Code Judicial Conduct Rule 2.11. Judge Glanville has been derelict in his judicial duties and must be recused. So my question is, do you guys think Judge Glanville has a personal thing against Steele and the defense attorneys, or if it's a personal thing against Young Thug himself? Because why would he want to insert himself this far deep into it? Because that's really like, you're really throwing your career out of the window for this one case. So who is it? Is it against Steele or is it against Thug? Both of them. Everybody said both of them. Both. Because this is just ridiculous. It says, once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon of June 10th, 2024 in open court, lawyers Hilton and Love sat mute, while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's lawyer Love and lawyers Hilton improper, illegal, and unethical conduct. Judge Glanville must be recused from any further action on Mr. Williams' case. Let's see. The reference sections of the Georgia Code of Judicial Conduct are meant to be self-enforcing, and it is the judge's duty to disqualify himself as soon as he is aware that the grounds exist, which provides that no justice, judge, or magistrate shall accept from parties to the proceedings a waiver of any ground for disqualification, including cases in which the judge has personal knowledge of disputed evidentiary facts concerning the proceedings. In the case at hand, the state cannot show that Judge Glanville's, lawyer Love's, and or lawyer Hilton's intentional and willful complicity in these ex parte communications was harmless error. As shown in Exhibit B, the improper influence and interjections by Judge Glanville and his two cohorts, basically his two hoes from the Fulton County District Attorney's Office on Mr. Copeland, changed Mr. Copeland's stance not to testify against Mr. Williams. If Mr. Copeland refused to testify, all of his prior false inculpatory statements as to Mr. Williams would not come into evidence based upon Mr. Williams' constitutional right to confrontation. Intimidation tactics thrust upon Mr. Copeland by the combined work of Judge Glanville, lawyer Love, and lawyer Hilton resulted in Mr. Copeland's decision to testify, and thus Mr. Williams has another witness to challenge at trial. Moreover, ex parte communications are so disfavored and repugnant that even if the ex parte communication would be cumulative of other evidence introduced at trial, same would not be harmless error because the ex parte communications are presumed to be reversible error. Steele is trying to take them down as a whole. Judge Glanville and his two hoes is about to go down. Still ain't playing the radio, okay? Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville's, Lawyer Love's, and Lawyer Hilton's improper, unethical ex parte meeting with witness Copeland. Moreover, the cover-up, secrecy, and silence of these three team members, not team members, is unforgivable. To wit, after the Star Chamber meeting, the three quote unquote boys still is petty public officials simply strolled into the courtroom, faced the cameras, called for the jury, and feigned to continue trial as if nothing out of the ordinary occurred just hours and minutes before. See YouTube. Let's see what YouTube channel he bringing up. Let's see. Oh, he got law and crime. Hold on, let's go back. I gotta go back. Let's reopen. Hold on. And see the timestamp he said. Hold on. Let's see. Page 8. Timestamp he said. Oh, he said 2:28 to 2:35. Let's go. Let's see. Can y'all see the video? Let's see. It's law and crime. $228.
Okay.
Okay.
All right.
All right, there we go. 228. Yeah, he said 228.40. Okay, let's see. Right, watch this.
Now in session, the Chief Honorable Judge Gerald Glanville will preside in court. Now come to order.
All right. Good morning, ladies and gentlemen.
Good morning, Your Honor.
All right, ladies and gentlemen, we are back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183 572. All right, let me go ahead and take roll for today. Let's see, Mr. Stillwell, Mr. Boston, Mr. Shar. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Mr. Adams. Good morning. All right, Mr. Kenrick and Mr. Weinstein. Good morning. All right, Mr. Huey and Mr. Matthews Jr. and Sr., good morning. All right, Mr. Nichols and Mr. Garner, good morning. Mr. Ryan and Misty Williams, good morning. All right, Mr. Brown, Mr. Uhelski, Mr. Atkins, Ms. Love, and Ms. Hilton, good morning, council. All right. Okay, Ms. Knight, Mr. Kokomo, was you here? No, not yet. Okay, Ms. Haltwinger, Mr. Mansbach. All right, good morning. Mr. Smith? That's right, it is Mr. Smith. He usually sitting next to Mr. Brown. That's why I usually kind of get the two of you mistaken, but that's my fault, sir. I'm trying not to let that happen again. All right. Are all of yours present, sir?
Little Rod
Okay.
leaked the information for some
All right.
oranges.
Anything I need to take up
He missed the oranges and snacks.
before we call for Mr. Copeland? All right. Mr. Steele, you don't have to if you don't want to. I mean, it's okay.
I want to.
All right, go ahead.
Oh, he thought Steele was gonna laugh.
We don't know what is going on. We know you said we're gonna have a hearing with his lawyers.
I'm sorry, I didn't quite hear you talking a little low.
I don't know what's going on. As I learned, you said that there'll be a hearing this morning with his lawyer. It's been dark since.
He's had okay. Mr. Copeland's had the opportunity to speak with his lawyer, Miss Bumpus, and it is my understanding he's going to testify. That's the latest I can give you. Okay. So we're going to bring Mr. Copeland out, and we'll see what happens. Okay.
Did the court send the immunity order?
It should be filed.
Okay.
There's it should be part of Odyssey at this point in time. Because it would have been filed, I think, on Friday. So
I don't believe anyone.
Ms. Love, did you file that already?
We left the yellow envelope with the court for a signature. We were going to file it under seal.
You mean the motion?
It was the motion and the order.
So she never filed.
Okay, all right.
We can give them.
Yeah, if you could send them a copy, that'd be fine. Okay.
Yes.
We're gonna need to send them a copy, so we'll send them a copy. All right. Can we bring out Mr. Copeland, please?
Dummies got caught. Let's go back to it. Let's see. All right, let's see. Mr. Williams needs to examine Judge Glanville, Lawyer Hilton, Lawyer Love, and all other members of their prosecution team to reveal the date and time of every ex parte communication that occurred concerning Mr. Williams' case since its inception, the subject of saying and ordered the court reported to produce any transcript of same and or unseal all documents from these potential improper ex parte communications. So just like we said, he feel the same way we feel. They've had several ex parte communications. So now I feel like we're all the other witnesses in these same meetings. Because I forgot who said it when we were talking. Tick did kind of switch up from the first day. So let's see. Undersigned counsel needs to cross-examine all of these parties to ensure that the sworn testimony is spread in open court on the record. Mr. Williams' trial is constitutionally broken based upon the unconscionable misconduct of Judge Glanville, Lawyer Love, and Lawyer Hilton, all working together in effort to convict Mr. Williams. The criminal justice system in Fulton County, in the state of Georgia, and in America has been attacked by the conduct of these three actors, bro. When I tell you who gave Brian Steele some Hennessy, because when he was writing this, he was on one. They went from cohorts to 3 hoes to a team to 3 actors. This injustice must end immediately, beginning with Judge Glanville removed and disqualified from Mr. Williams' case. Thereafter, this motion is also timely made for Lawyer Love and Lawyer Hilton to be removed and disqualified from Mr. Williams' trial, and the Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of Lawyer Love and Lawyer Hilton. Judges must, hold on, let me get it right, scrupulously, is that right, y'all? Avoid improper ex parte communications, whether or not they consider them. A judge has the ethical duty to recuse himself sua sponte anytime the judge is aware of grounds to do so. Sierra talking about, I don't know about that one. That one was a little off. Judge Glanville did the opposite of recusing himself sua sponte, even though he is keenly aware that helping Lawyer Love and Lawyer Hilton to influence Mr. Copeland to change his mind and testify against Mr. Williams is not permitted by any judge. Okay. Shut up, Slick. In any court. Instead, Judge Glanville, the chief judge in the Superior Court of Fulton County, Georgia, has taken upon himself, at the behest and encouragement of lawyers Love and Hilton, to ally himself with the prosecutors in this case. Judge Glanville's misconduct shall not stand. The law must be followed. Judge Glanville must be recused and disqualified from Mr. Williams' case instanter. No hearing is actually needed to reach the finding that recusal of Judge Glanville is mandated. Judge Glanville has automatically caused his recusal and disqualification from Mr. Williams' case by unlawfully becoming actively involved when he presented argument refuting affiant's allegations of judicial bias. See YouTube dated July 1st. Let's see. I don't know which one this is. And what time he said? 2 hours, 38 minutes. Let's see. Two hours and 38 minutes. Boy, still be on it. He love him some long crime. Let's see. Let's share this one. 2 hours, 38 minutes.
Stage. And now, Mr. Copeland was a sworn witness, and third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues provided that the judge reasonably believes that no party will gain any
Okay, see this when he goes
procedural,
that whole
substantive, or
long
tactical
spiel.
advantage as a result of the ex parte communication. And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed. So everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit and before any other further examination of Mr. Copeland. I'll address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had and the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who was there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986.
Slick, I think he was forced to take this break.
Presence
I
of
know
the accused.
because he was sick.
Although an ex parte
he was
conference to
forced to
discuss threats against the witness is proper,
I think once the
district court
motions
must
start
ensure
coming
that
back
the
to back,
conference
he
is
can't help
carefully
but
conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contend that the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations, the trial judge may find an ex parte conference necessary. Cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983 where the court cites in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may in rare circumstances feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about the threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. They see United States versus Arroyo and it's ANGULA. It's at 580 F second, 1137 pinpoint,
Right now, nothing
1152,
about, I didn't hear
1142,
anything about
1141,
that man
1142,
feeling threatened
Second
at
Circuit
all.
case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got a citation for that being
Oh, my bad, Lee.
439
Oh, yeah.
US 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair.
Yeah,
First,
when
at
I
no
speak,
time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F second, 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close.
Definitely too
The
late.
portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements
And I
from his
think
testimony.
it
The
came
court had
to
already
a
learned
point
all it needed
where it
concerning
was
the
like, now
witness's fears and the
everybody is
prosecutor's
trying
plans
to
for
save
protection,
themselves.
there being no reason to
They went in as a
participate
group.
in such
Now
coaching.
everybody is
Second
single-handedly
problem
trying to
occurred
save
where
themselves.
Pooley took the stand.
Because
Defense
why
counsel
Hilton,
inquired about what inducements had been given for Pooley's testimony,
when
and the
Love, I guess,
prosecutor and
had the
Pooley both
quote-unquote
indicated
family
only the promise.
emergency, why couldn't Hilton file the motion? I feel like now Hilton just won't out of it completely, but she too far in. She too far gone.
Was that the only promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed. Similarly, in this matter,
Somebody want to do the honors in 86 quick?
the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out, and you can have a look at that. The court's also
Let's go back. All right, let's see. With it. Okay, it says, if this honorable court disagrees, Mr. Williams respectfully requests a hearing as he will call Judge Glanville, Lawyer Love, and Lawyer Hilton as witnesses to fully unmask this above discussed misconduct as well as further misconduct that may have occurred. This judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts. The Fulton County District Attorney's Office stains courts throughout the state of Georgia and our country. What occurred in this star chamber, outside of the view of the cameras, in the shadows, and hidden from Mr. Williams and his counsel and the public, is unpardonable and in all violation of Mr. Williams' constitutional rights stated herein as well in Exhibit A. Judge Glanville, Lawyer Love, and Lawyer Hilton have created secret star chambers proceedings which the state of Georgia has promised its citizens it would never engage. As the Honorable Supreme Court of Georgia has taught, justice faces its greatest threat when the courts dispense it secretly. Our system abhors Star Chamber proceedings with good reason. Judge Glanville, Lawyer Love, and Lawyer Hilton have teamed up to conduct their illegal and unethical conduct outside of the view of Mr. Williams and his counsel, the public, and outside the lens of the cameras. These quote unquote public officials shall never be trusted by Mr. Williams or undersigned counsel. There are serious consequences for these intentional and unjustified misdeeds that have not yet been dispensed. The clear evidence is that Judge Glanville is not impartial, and or there is at least the appearance that Judge Glanville is not impartial. Judge Glanville must be removed, disqualified from Mr. Williams' case. As sworn to in Exhibit A, Judge Glanville, Lawyer Love, and Lawyer Hilton conspired. Okay, still trying to get them a Rico. Still is trying to get them a Rico to conceal and suppress Brady v. Maryland evidence. The Star Chamber cannot prohibit Brady evidence from coming forward. That is exactly what Judge Glanville, his hoes, Lawyer Love, and Lawyer Hilton plan to do. Mr. Williams' constitutional right to due process, a fair tribunal, a fair trial, effective assistance of counsel, right to cross-examine, right to see, hear, and be present for the statements of a sworn witness have been obliterated by Judge Glanville and his hoes. Judge Glanville must be removed as he has forfeited his position as judge. The June 10, 2024 Star Chamber meeting between Judge Glanville and lawyers Love and Hilton undermined the public's faith in the integrity of the justice system as it conceals from the public. Mr. Williams, his lawyers, and the others facing the removal of their liberty-critical information about the lawfulness and reality of how they are prosecuted. This injustice must end today. This trial is wholly broken and cannot ever be repaired based solely upon the improper conduct of Judge Glanville, Lawyer Love, and Lawyer Hilton. Any motion for mistrial made by Mr. Williams is based exclusively upon the improper actions of the supposed judge and state actors. Judge Glanville at the indecorous Star Chamber ex parte meeting provided legal advice and direction to Attorney Bumpus about how to speak with her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of partiality, which is a proper ground for the granting of this motion to recuse under our Code of Judicial Conduct and a constitutional violation of due process. Mr. Williams' constitutional right to due process has been violated because not only is there an appearance of partiality, but there is actual bias as Judge Glanville has been embroiled in this trial and is assisting the prosecution to attempt to gain a conviction of Mr. Williams. It is impossible for any reasonable person to believe that Judge Glanville is neutral. Judge Glanville must be removed based upon the one ex parte communication that has come to light thus far. Judge Glanville, lawyers Love and Hilton have infected the process of Mr. Williams' trial and have illegally poisoned sane forever. Judge Glanville had the ethical duty to recuse himself sua sponte once he had these ex parte communications. However, neither Judge Glanville, Lawyer Love, nor Lawyer Hilton uttered a word that they spent the morning of June 10th, 2024, leaning on Mr. Copeland to testify for the prosecution against Mr. Williams, coaching Attorney Bumpus on what and how to sell to Mr. Copeland the proposition to cause him to testify at trial against Mr. Williams, coaching Mr. Copeland on how to deliver his testimony, and promising Mr. Copeland that he would not be prosecuted even for perjured testimony unless he told a bold-faced whopper lie. These quote-unquote public officials heard and failed to reveal that Mr. Copeland confessed to committing every indicted offense in this case. Even non-lawyers can see that Judge Glanville, Lawyer Love, and Lawyer Hilton are not acting in an ethical manner, are on the same prosecutorial team, and that Judge Glanville should not be rewarded with the opportunity to continue to preside as judge over Mr. Williams' jury trial. In reality, Judge Glanville, Lawyer Love, and Lawyer Hilton have made themselves witnesses whom Mr. Williams' counsel will call these three lawyers. That is the most disrespect, even though, yes, the judge is a lawyer. For him to call that man, to demote that man to just a lawyer is so disrespectful. Must be recused and removed from this case. I don't know if y'all see him, but you can tell that the more and more Steele was writing this, he was getting more and more pissed because his insults just get bigger and bigger. It is important to note that Judge Glanville originally denied Mr. Williams' request for access to the June 10th, 2024 ex parte hearing transcript, keeping contents of the record totally hidden by Lawyer Love, Lawyer Hilton, and Judge Glanville. Fortunately, mounting pressure related to Judge Glanville's gross misconduct, violation of his oath of office, ethical violations, and potential criminal conduct by Lawyer Love, Lawyer Hilton, and Judge Glanville worked to effect change. He's trying to put a Rico on these people. Boy, they all going down. On Monday, June 17, 2024, Judge Glanville denied undersigned counsel's motion to recuse and went forward with the trial of this case. Similarly, Judge Glanville denied the Honorable Doug Weinstein's Esquire. Okay, I want to know what's the difference between Esquire and lawyer. Do y'all know that? I want to know the difference because I see some attorneys have Esquire at the end of their name and then some don't. Motion to recuse on June 12, 2024, Judge Glanville then continued to unlawfully preside over Mr. Williams' jury trial. Judge Glanville must be removed as he has proven he have actual bias as well as the appearance of bias. Mr. Williams' counsel has announced in open court that he will call these three offenders, convicts, felons at trial. Judge Glanville's, Lawyer Love's, and Lawyer Hilton's name appear on Mr. Williams' filed 8 amended list of witnesses. Undersigned counsel has never been afforded the questions that Lawyer Hilton and or Lawyer Love created and gave to Mr. Copeland. As a sign of respect. Okay. Undersigned counsel has never been given this list of questions, even though Judge Glanville has been made aware of these questions and has encouraged Attorney Bumpus and Mr. Copeland to review and understand these questions. The question must be asked why Judge Glanville has ex parte access to Lawyer Hilton and or Lawyer Love's questions for a witness. This conduct is beyond repair. Judge Glanville, Lawyer Hilton, and Lawyer Love did not give a hint that they were meeting ex parte with witness Copeland on the morning of Monday, June 10th, 2024, or at any time. Undersigned counsel had no idea that Judge Glanville, Lawyer Love, and Lawyer Hilton would dodge the law and ethical rules to conduct this improper and unethical ex parte conference. Judge Glanville and lawyers Love and Hilton were duty bound to immediately announce to Mr. Williams, his counsel, and all accused and their counsel that this ex parte meeting occurred. Brady and Gigolo evidence was obtained, and that the transcript was made and allowed argument to flow. Instead, their cover-up equals their misdeeds. Boy, still dropping these doggone YouTube videos like nothing. I think this is this the same one though? Oh yeah, this is the same one we watched. Judge Glanville, lawyers Love and Hilton, acting in concert, hid Brady evidence and attempted to normalize this unconstitutional Star Chamber meeting, unethical conduct, and witness intimidation by deflecting the focus on how undersigned counsel learned of the secret proceeding. Judge Glanville held undersigned counsel in contempt of court. This misconduct by Judge Glanville, Lawyer Love, and Lawyer Hilton undermines trust in judges and prosecutors, cannot stand, and cannot be rewarded. Action must occur in order to attempt to remove this dark cloud over Mr. Williams' trial and the criminal justice system at large. The conduct of Lawyer Love, Lawyer Hilton, and Judge Glanville can never be forgotten, normalized, or ratified. The Georgia courts have always safeguarded and separated prosecutors in their duties from judges in their duties. Here, there is no daylight between Judge Glanville's and Lawyer Hilton's and Love's improper and unethical conduct. All must be removed from Mr. Williams' case. As stated herein, Mr. Williams intends to call Judge Glanville as a witness at trial, as well at this recusal motions evidentiary hearing based upon his improper conduct and the need to make a further record to protect Mr. Williams' constitutional rights. Specifically, there appear to be communications not captured on the transcript of June 10, 2024, ex parte meeting. Lawyers Love and Hilton and Judge Glanville's examinations are needed to complete this record. Judge Glanville is a necessary witness in Mr. Williams' trial, and his name will be used when undersigned counsel cross-examines Mr. Copeland when asking questions: 1, whether Judge Glanville pressured Mr. Copeland to testify; 2, whether Mr. Copeland realized that Judge Glanville was allowing wrong propositions of law to be explained to him; and 3, the fact that Judge Glanville condoned Mr. Copeland lying under oath unless it was a bold-faced whopper. This mandates that Judge Glanville not be in the courtroom in front of Mr. Williams' jury ever again as a judge. Judges must be disqualified in proceedings in which their impartiality may be reasonably questioned, including, but not limited to, instances where the judge is likely to be a material witness in the proceedings. Grounds for recusal are contained in OCGA 15-1-8, as well as the Georgia Code of Judicial Conduct. Further, the judge should be disqualified for bias against a party if such bias stems from an extrajudicial source and results in an opinion on the merits on some basis other than what the judge learned from his participation in the case. The alleged bias of the judge must be of such a nature and intensity to prevent Mr. Williams from obtaining a trial uninfluenced by the judge's bias. Let's see. Under Rule 2-11 of the Code of Judicial Conduct, a judge must avoid all impropriety as well as the appearance of an, what's the word, y'all? Y'all ain't in the chat no more? Why I don't see my chat? Somebody comment. I can't see the chat no more. Hold on, y'all. I can't see the chat. Hold on. Let me just put YouTube up on my phone. Hold on. I can't see the chat on StreamYard. Okay, I got it up on my phone now. I don't know why I can't see it on StreamYard. Hold on. Impropriety. Judges shall disqualify themselves in proceedings in which their impartiality, did I read this already? Might reasonably be questioned. The fact that judge impartiality might reasonably be questioned is grounds to mandate that he is removed from this case. Provides an additional rule of disqualification that is broader than our statute. Here, under any definition in any rule, Judge Glanville must be removed from the position of judge. In fact, commentary 2 to Rule 211 explains that judges are subject to disqualification whenever their impartiality might reasonably be questioned. Judges should disclose on the record information that the court believes the parties or their lawyers might consider relevant to the question of disqualification, even if the judge believes there is no legal basis for disqualification. Okay, now you got all this. This is going over the court cases. Judge Glanville, blah, blah, blah. Okay, it says Judge Glanville must leave Mr. Williams' case except when he is called to testify as a witness to explain under questioning his misconduct and bias before the jury. The bias of Judge Glanville is of such a nature and intensity to prevent Mr. Williams from obtaining you know what? Lee, go ahead. Go on 86 Slick. And Sierra. All right now. From obtaining a trial free from Judge Glanville's bias and prejudgment. Prejudice, bias, or prejudgment, or even an exhibition of partisan feeling is present in Mr. Williams' case, and Judge Glanville must be removed. Mr. Williams asks this honorable court to hold an evidentiary hearing on this motion to recuse in order for Mr. Williams to gain a full understanding of the misconduct of Lawyer Love, Lawyer Hilton, and Judge Glanville throughout this case. Judge Glanville is so involved in this controversy that his objectivity can reasonably be questioned, and he must be removed as a judge over Mr. Williams' jury trial. The facts are so clear that Judge Glanville, in order to shield himself and his co-prosecutors, Love and Hilton, from the truth of their misconduct, denied Mr. Williams' June 17, 2024 motion to recuse without a hearing, without providing a transcript, and without permitting another court to hear the motion to recuse, dated Monday, June 17, 2024. This demonstrates that Judge Glanville is involved in this controversy and cannot be deemed fair and impartial. Significantly, Judge Glanville is required to avoid not just impropriety. I can't say that. Look, now I feel like y'all, I can't say that. Okay, can't say that. I feel like I sound too country, but the appearance of in his activities. This is because public confidence in and respect for the judiciary and of our courts must be maintained, as shown in Exhibit A, available attached here too. Okay. It has been held to be elementary that a judge must be disqualified when he is going to be a witness in the same proceeding. Okay. Judge Glanville attempted to cover up his and Lawyer Love's and Lawyer Hilton's misconduct by attempting to intimidate undersigned counsel and then holding undersigned counsel in contempt of court, sentencing undersigned counsel to the maximum number of days to serve in custody for doing nothing but zealously and ethically upholding his professional responsibilities. Judge Glanville then took action before the jury after recusal motions were timely filed by the Honorable Douglas Weinstein, as well as undersigned counsel. All of these actions taken by Judge Glanville after these ripe and valid recusal motions are filed or void. Were filed or void. So is he saying that all these actions taken by judges are filed or void? So he's basically saying when Weinstein filed that motion, because he denied Weinstein motions, didn't he? That motherfucker in our 86. You bet not block Sierra D. Stop that. Judge Glanville has caused Mr. Williams immeasurable suffering and prejudice based upon his, Lawyer Love's, and Lawyer Hilton's denial of Mr. Williams' statutory and constitutional rights stated herein. Mr. Williams must be granted a reasonable, must be granted a reasonable bond. Mr. Williams' statutory right to speedy trial has been totally upended by Lawyer Love, Lawyer Hilton, and Judge Glanville, and Mr. Williams must be cleared of all baseless charges. As spelled out above, this supplement to motion to recuse is timely filed, as same as filed no later than 5 days after undersigned counsel affiant first learned of these additional grounds for disqualification, to wit, on Monday, July 1st, when the ex parte transcript was first revealed. Oh, he must got a date wrong. It was first revealed to undersigned counsel. The attached joint affidavit memorialized as Exhibit A supports this recusal motion by giving fair support to the charge that Judge Glanville's bent of mind may prevent or impede impartiality as required for Judge Glanville to preside over this case. Judge Glanville's extrajudicial misconduct cannot be ignored. Judge Glanville, Lawyer Love, and Lawyer Hilton have worked in lockstep to ensure Mr. Williams' constitutional and statutory rights to a fair trial, impartial tribunal, due process, right to be present at all critical stages of his trial under the federal constitution, as well as Article 1, Section 1, Paragraph 11 of the Georgia Constitution, right to cross-examine, right to present a defense, right to effective assistance of counsel, right to assist his counsel, have all been crushed. This trial is a farce. Denying this motion to recuse, permitting Judge Glanville to continue as judge, perpetuates injustice. This case can never return to constitutional normalcy based solely upon the improper misconduct of Lawyer Love, Lawyer Hilton, and Judge Glanville. Any tragic conviction and sentence in this case will likely be reversed. Judge Glanville has made himself a necessary witness, as has Lawyer Love and Lawyer Hilton. Should Judge Glanville not recuse, Mr. Williams will be prevented from exercising his constitutional right to call witnesses, as Mr. Williams needs to show the jury how and why Lawyer Love, Lawyer Hilton, and Judge Glanville were not just doing their jobs, but were teaming up with a united front to convict Mr. Williams. Once armed with this evidence, the jurors can then properly determine what, if any, of this testimony and these facts will bear on their verdict. Judge Glanville must be removed. Now what happened on the 18th? I better not help you no more. It's easier to. Oh, you really tried me, D. Baby, you see how fast we getting through this? Don't try me. I haven't. I'm trying to go down back to it so I can see the timestamp on this last video. Oh, okay, hold on. God dang. It's 27:41. You know what? Keep it up, D. Made me lose my place. Oh, it's right here. We got like 3 more pages, y'all. And this took us how long? Blocked himself for 10 seconds. Who blocked who? Keep it professional, Slick.
I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right, thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022. The lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I've added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it
Yeah, D, let's do
entirely,
that tonight. We
I
can
don't
do
believe
on
that
your
meets
turn.
a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your
That was so
affidavit, Mr. Steele, and
disrespectful. Just blow
I've
his nose
consumed
in the
everything
mic.
on it, and that doesn't
This
change
is
my
the
ruling at this
most
point in time, respectfully.
disrespectful
I
judge
also,
in the
on
world.
the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm
how.
not gonna, Mr. Steele, I can't argue with you about anything such as, I've made my ruling, okay?
I
If you
made
have
my
some other
ruling.
basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading, but
I made my ruling. Yeah, and I wanna we gotta pull that case where they tried to cite and the whole time still was over that case. Mr. Williams, June 17, 2024, motion to recuse in the attached affidavit clearly met the threshold requirements of USCR 25-3. This June 18, 2024 ruling clearly shows the bias of Judge Glanville. On Monday, July 1st, 2024, Judge Glanville allowed undersigned counsel's June 17, 2024 motion to recuse to be forwarded to another court. While this shows that there is at least a reasonable appearance of impropriety, there you go, by Judge Glanville, judges shall disqualify themselves from any proceeding in which their impartiality might reasonably be questioned. Judges shall perform judicial duties without bias or prejudice and shall not, in the performance of judicial duties by words or conduct, manifest bias or prejudice. Judges shall be faithful to the law and maintain professional confidence in it. Judge Glanville has violated all of these critical and worthy principles. Judge Glanville had the duty to act at all times in a manner that promotes public confidence. Hold on, nobody paid these pages right. Where I stop at? Has violated all of these critical and worthy principles. Judge Glanville had the duty to act at all times in a manner that promotes public confidence in the impartiality of the judiciary. As seen in Exhibit A, Judge Glanville has abrogated his duty. A hearing must be held to properly document the misconduct between Lawyer Love, Hilton, and Judge Glanville. A full evidentiary hearing must be conducted where Lawyer Love, Lawyer Hilton, and Judge Glanville will be called by undersigned counsel as witnesses to determine the nature and scope of their relationship, which basically means those his hoes. So you was the Woody this whole time, not me. Sierra, please. Of their relationship and misconduct. Before the jury, Judge Glanville will be spoken about in terms of his work as a member of the prosecution team. Judge Glanville will be called as a witness by Mr. Williams. The law mandates that Judge Glanville be removed from presiding over Mr. Williams' case because he cannot be both a witness and judge in our lawful criminal justice system. Judge Glanville has given Lawyer Love, Lawyer Hilton, the Honorable Attorney Bumpus, and Witness Copeland legal advice. Mr. Williams' jurors need to understand who has been orchestrating this kangaroo court. Judge Glanville, Lawyer Hilton, and Lawyer Love should have separate and distinct roles in our criminal justice system. The distinction between these roles has been washed away in Mr. Williams' case. When the judge instructs Mr. Williams' jury that by no comment, ruling, or action taken by the trial court should the jury determine that the judge has any bias in favor of a party, this will be a disputed point of law. Mr. Williams will be calling Judge Glanville, Lawyer Hilton, and Lawyer Love as witnesses, and thus this instruction does not apply to Mr. Williams' case. Mr. Williams' jurors must learn the conduct of these three lawyers when examining the evidence and evaluating this instruction. Judge Glanville is a necessary witness in Mr. Williams' trial and must be recused. Lawyers Love and Hilton are necessary witnesses in this case and must be disqualified. As attested to in Exhibit A, Judge Glanville received extrajudicial information and also gave opinions and legal advice that included, but are not limited to, that Mr. Copeland went to prison for crimes committed on behalf of YSL, a contested fact in this trial. Mr. Williams and the other co-indictees know Mr. Copeland and his criminal conduct that is not known to Judge Glanville or the prosecutors. Mr. Copeland will be cross-examined on his other crime evidence because Mr. Williams and the co-indictees have far greater knowledge of Mr. Copeland and his background than others. And the like. By embracing this extrajudicial information, Judge Glanville believes that Mr. Williams is involved in criminal activity with Mr. Copeland, and Judge Glanville expressed that fact to Mr. Copeland in order to push Mr. Copeland to testify against Mr. Williams. These conclusions regarding facts that are in dispute about Mr. Williams' guilt mandate Judge Glanville be removed from this trial. Moreover, Judge Glanville's derogatory and prejudicial statements and demeanor must be considered by this honorable court as attached in Exhibit A. Judge Glanville had an ethical duty to disqualify himself in this manner, as he clearly has a personal bias and prejudice concerning Mr. Williams, the other co-indictees, Mr. Williams' counsel, and the other defense lawyers in this case. Judge Glanville has violated his oath by not voluntarily disqualifying himself to avoid this appearance. Instead, Judge Glanville, Lawyer Love, and Lawyer Hilton has manufactured an unfair, unconstitutional, broken trial and has caused Mr. Williams severe prejudice by incarceration for over 2 years without bond in a laughable trial that has lasted entirely too long with the games played by Lawyer Love, Lawyer Hilton, and Judge Glanville. Judge Glanville must be removed. The instances discussed herein, as well as in Exhibit A, represent more than mere friction between zealous counsel and a diligent jurist. Judge Glanville's conduct created the realistic impression that he has harbored an inclination to be biased against Mr. Williams and partial towards Lawyer Love and Lawyer Hilton in the Fulton County District Attorney's Office. Although proven, this honorable court need not decide whether such bias or impartiality actually existed because Judge Glanville was ethically bound to disqualify himself whenever his impartiality might reasonably be questioned, including instances where Judge Glanville's behavior could indicate that he has a personal bias or prejudice against a party or a party's lawyer. Judge Glanville's impartiality is more than questionable, and it is error to permit him to continue on Mr. Williams' trial. As shown herein and in the attached affidavit, Judge Glanville is disqualified from any contact with this case moving forward based upon his bias against Mr. Williams and or his counsel, which stems in part from extrajudicial sources and results in an opinion of the merits on some basis other than what Judge Glanville learned in his lawful participation in this case. As cited above, ex parte communications are presumptively harmful error. The state has the burden of rebutting the presumption of harmful error, which it will not be able to do. Thus, any conviction and sentence will likely be reversed. Moreover, the issue surrounding the improper, secret, and coercive pressure campaign by Judge Glanville, Lawyer Love, and Lawyer Hilton will become evidence before the jury. In order to attempt to explain this injustice to the trier of fact, Judge Glanville, Lawyer Love, and Lawyer Hilton will become witnesses. Mr. Williams is entitled to know these communications between Judge Glanville, Lawyer Love, Lawyer Hilton, and or Mr. Copeland. Judge Glanville, Lawyer Hilton, and Lawyer Love have stolen forever Mr. Williams' opportunity to have this trial heard by a jury in a constitutional and statutory firm manner. Judge Glanville, Lawyer Hilton, and Lawyer Love have goaded Mr. Williams into moving for mistrials. All of the conduct and all proceedings after the Honorable Douglas Weinstein, as well as undersigned counsel, filed their motions to recuse, and affidavits were deemed invalid and have no effect. Mr. Williams' constitutional and statutory right to a speedy trial has been stomped on by Judge Glanville, as well as Mr. Williams' right to due process in a fair tribunal and the other constitutional rights stated herein and in the attached affidavit. This conduct must end, and all three of these lawyers must be disqualified from this case. The attached affidavit clearly sets forth the facts and reasons for the belief that prejudice and bias exist. These allegations are definite and specific as to time, place, and details as to this extrajudicial conduct or statements which demonstrate both bias in favor of Lawyer Love and Lawyer Hilton in their position on behalf of the District Attorney's Office of Fulton County and prejudice toward Mr. Williams and his counsel. Moreover, there has been a systematic pattern of prejudicial conduct towards Mr. Williams and his counsel and other co-indictees in their counsel by Judge Glanville, Lawyer Love, and Lawyer Hilton acting together unethically, which has influenced the trial process and has broken the foundation of a fair trial. These are not bare conclusions or opinion, as Judge Glanville attempted to claim. Mr. Williams timely filed his motion to recuse on June 17th. Instead, Judge Glanville was using his position of power and trust to obstruct justice. This man is about to get him a whole RICO case dealing with Brian Steele, as he has violated his oath of office while Lawyer Hilton and Lawyer Love sat mute as they violated their oath of office and their ethical responsibilities to ensure a constitutionally fair trial. Lawyer Love, Lawyer Hilton, and Judge Glanville must be disqualified from further action. Mr. Williams must be released from custody and cleared of all charges based upon prosecutorial and judicial misconduct. As explained above, ex parte communications are presumed to be error, and once Mr. Williams has shown that Judge Glanville received ex parte communications, there is a presumption of harm that can only be overcome by affirmatively showing that Judge Glanville did not consider these communications. In this case, Judge Glanville has harmed to his core Mr. Williams' constitutional and statutory rights asserted herein. Judge Glanville, Lawyer Love, and Lawyer Hilton are now self-made witnesses and must be removed from this case. Their conduct is reprehensible. Judge Glanville has never affirmatively stated that he has not considered these ex parte communications. Lawyer Love and Lawyer Hilton and Lawyer Love have never uttered a syllable denouncing these ex parte communications. Instead, they promote their propriety of these ex parte communications. The state cannot refute this presumption of harm, as Mr. Williams' constitutional right to cross-examination, fundamental rights to present, to hear all goings on in the court pursuant to the United States Constitution, as well as Article 1, Section 1, Paragraph 11 of the Georgia Constitution. Okay, he's definitely saying the same thing over and over again, basically. Okay, this is where he gets into the Judge Krause. The law also requires this honorable court to recuse. The public must believe in the absolute integrity and partiality of judges. That is why, even without showing of actual bias, prejudice, or unfairness, and regardless of the merits and timelessness of any motion to recuse. It is inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court which sits in the same circuit. The Supreme Court of Georgia observed that our Judicial Qualifications Commission has opined that a judge in a particular court should never preside over a matter concerning another judge from the same circuit. The Honorable Court of Appeals of Georgia has explained that as cited above, the commission concludes that it would be inappropriate for this honorable court, talking about Judge Krause, to preside in this action where Judge Glanville holds a judicial office in this honorable court's same circuit. Therefore, under law, this honorable court must recuse from this case because refusing to do same would permit questioning of this honorable court, something the courts will not continue. This court must recuse as well. An appearance of impropriety exists in situations in which reasonable minds might perceive that this honorable court's ability to carry out its responsibilities with impartiality and integrity or competence is impaired. Furthermore, this honorable court has received a $2,000 donation to its re-election campaign from Judge Glanville in April 2024 during the pendency of Mr. Williams' trial. Judge Glanville, given this contribution for re-election, could be deemed an exceptionally large campaign contribution, and thus is another reason this honorable court must recuse from presiding over this case. And that's it. Let's see. Who you call a penny? So I'm in here just wasting my time reading and it's the Slick D and Sierra show. You dislike, you know what? Bro, what is wrong with y'all? Bro, y'all play all day. I am weak. Slick, I need some lunch money for the rest of the week. I am weak. When did he file? Oh, Exhibit A. So the joint affidavit of Brian Steele and Keith Adams. Child, I need me a shot. Can y'all give me a super chat of a shot of Casamigos? Let's see. We are over the age of 18 and suffer no legal disability. We make this joint affidavit. Lord, kids is bad. Scroll on down. Let's see. Let's see if he said anything different from what he said in there. Lawyer love, again, this unethical parte conference by explaining that the state's reason for Judge Glanville to meet with sworn witnesses to impress upon Mr. Copeland that he needs to testify for the same reasons Lawyer Love announced in open court on Friday, June 7th. At this point, rather than acting as a true judge protecting our court system and its reputation by questioning, why am I meeting ex parte and why am I being used to answer in front of only members of the state of Georgia questions of Mr. Copeland? Yes, a shot this early, Slick. Let's see. Do y'all want me to go through this affidavit? Because I think he's just breaking down of what was said in the transcript. Look at number 9. Lawyer Love continues to make false representations, and Judge Glanville knows if he has paid attention at all during the proceedings that Lawyer Love makes intentional misstatements of fact routinely, yet Lawyer Love deflects her misconduct and cites the ethical rules of conduct for attorneys during this ex parte hearing. Okay, let's see. What's the timestamp? 4 hours, 28 minutes. Let's see. Nurse is very rich. Just to let y'all know, she's my sponsor. Slick too. D, we ain't gonna forget about you either. Hold on, y'all. What did he say? What timestamp? 4/28/35.
Then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial because.
Okay.
Okay.
All right, sir. Thank you. All right. Yes, sir. It would apply to everyone. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record
Sure.
regarding
Yes, I need to
Mr. Copeland.
Slick,
As we stated earlier, Mr. Copeland has.
Your Honor, I'm just telling the court, I am not accepting the proffer.
Your Honor, if I may.
Okay, but counsel gets the proffer, Mr. Steele. That's I can accept that. So could you sit down at that time, sir?
Sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court, the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay. All right. Thank you, sir.
while Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does he at any point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
No. As what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses, this particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks. And after Mr. Copeland has communicated to this court, he will testify. So watching the goings on as Mr. Copeland is not on the stand, it has been publicized, it has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question whose interests he's representing. And so we would ask that, you know, what I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person. And I don't know, I guess they're, you know, I don't know what's going on, but I can say that this entire day, starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning. So, Your Honor, as to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him. And I'm not even certain what is going on behind me with respect to persons who are purporting to represent the best interest of Mr. Copeland. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County Jail. But that's just my opinion. So, Your Honor, I would ask that the court deny the motion for a mistrial at the very least. And if it goes any further, find that actions by people other than the state have led to us being where we are, because Mr. Copeland was at the point right before lunch of agreeing to testify. That is the reason we were ready to get started right before lunch, because now he's been told he's going to be hammered by his attorney. I guess he told him that I guess the state's going to hammer him. I don't even know what, but Ms. Hilton has gone over the questions that she has for Mr. Copeland. She has spoken with him about it. They have been speaking cordially with one another. And this idea that somehow someone is entitled to a mistrial as a result of this action on the part of Mr. Copeland is a farce under these circumstances. We'd ask that the court deny the motion.
All right. I'm going to deny the motion for mistrial, Mr. Steele.
So she said Mr. Copeland was nothing but respectful and everything else. But while she was doing all that, was that before? I think that was that before? While she was doing all that, Mr. Copeland was posting this. That don't seem like he was getting along with their asses. Clearly, he said, they called me a week before Zari's birthday. Fuck them. So clearly, she ain't do nothing but sit up there and lie for whatever reason. I don't know what's up with old people in these lies. Let's see up here. See what else they got. He said that he only liked Miss Weaver. Let's see what 10 say. Lawyer Love explains the need for the ex parte communication. All that aside, we would like an opportunity for the court to address Mr. Copeland with Mr. Copeland's stand-in counsel present to allow Attorney Bumpus an opportunity to explain to Mr. Copeland everything that Lawyer Love has just said. Let's see what else. Says Judge Glanville becomes an advocate for Mr. Copeland to testify against Mr. Williams by telling Attorney Bumpus how to communicate with her client. Mr. Copeland specifically that Mr. Copeland is going to face some pretty significant cross-examination. And Judge Glanville explains to Attorney Bumpus that it is all in the message and the packaging in terms of, I think Mr. Copeland is, a very savvy person. But he's certainly going to be subject to a thorough and sifting cross-examination. The fact that Judge Glanville is dispensing legal advice and strategies to Attorney Bumpus, guiding her on how to speak with Mr. Copeland in order to have her client testify against Mr. Williams, is a clear, direct fact that Judge Glanville has forfeited his judicial role. Yeah, he's just breaking down the transcript. Judge Glanville, along with Lawyer Love, continues to advise Attorney Bumpus what to tell her client. For instance, part of Mr. Copeland's challenge, Attorney Bumpus, that may be that you need to ensure Mr. Copeland, look, I'm going to be here. And if you think that they're asking you a question, they being the state or the defense is asking you a question that's going to bring out other crimes that you are going to, Mr. Copeland is going to be able to look at you and say, can I have a chance to talk with you? Lawyer Love, who was working in lockstep with Judge Glanville, states that's exactly right. Lawyer Love then inaccurately bashes Attorney Melnick by saying, there's been an assertion that people are representing Mr. Copeland's interests. The biggest concern is Mr. Copeland's best interest, and then they are just not here. There is absolutely no reason that Judge Glanville and Lawyer Love are discussing what Attorney Bumpus should be telling her client, and no reason for Judge Glanville to permit Lawyer Love to ridicule Attorney Melnick. Lawyer Love, again, misrepresents by claiming that the Honorable Attorney Melnick has been talking to Brian Steele and Max Sharp. That's it. He's not talking to us. Why does Judge Glanville hold this ex parte conference and permit Lawyer Love to falsely accuse Affiant and the Honorable Attorney Maxwell Sharp of obstruction and ethical violations by influencing a lawyer-client relationship. This is extrajudicial information that Judge Glanville should have never received. Says he also, I think he put honorable in front of Kayla's name like once. But thereafter, Judge Glanville and Lawyer Love jointly explained to Attorney Bumpus that Attorney Melnick injected himself in these proceedings. The fact that Judge Glanville is having these conversations in the first place, then agreeing with and championing the prosecution's cause mandates, even to a casual observer, that Judge Glanville is biased against Mr. Williams and favors the prosecution. This great bias cannot be more clear when Judge Glanville explains to Attorney Bumpus that she needs to give to sworn witness Copeland the questions that the state is going to ask him when he testifies, and to ask Mr. Copeland to tell Attorney Bumpus any other facts that they, meaning Williams and his co-indictees, might ask about. Further, as long as Attorney Bumpus has knowledge of other crimes that sworn witness Copeland has committed, Judge Glanville states that Mr. Copeland will be fine because the state is only going to get into the questions that was provided to Mr. Copeland. It is ridiculous to claim that Judge Glanville is not biased and is impartial. Judge Glanville continues explaining to Attorney Bumpus that the reason she needs to know from Mr. Copeland what crimes he has committed in the past is the defendants know more about Mr. Copeland than anyone else. So they're probably going to what gives Judge Glanville the right to state that Mr. Williams know more about Mr. Copeland's supposed bad conduct than anyone else? In reality, Mr. Williams hardly knows Mr. Copeland. Judge Glanville has pronounced guilt onto Mr. Williams. Judge Glanville imparts legal direction to Attorney Bumpus on how to prepare Mr. Copeland for cross-examination and how to prepare Attorney Bumpus to object on behalf of Mr. Copeland. Judge Glanville has tarnished this trial forever, as Mr. Williams could never have a fair trial with the way Judge Glanville has acted, both in front of the jury and outside of everyone's presence in the ex parte meetings with Fulton County District attorneys and witnesses. Says the conduct of Judge Glanville, Lawyer Love, and Lawyer Hilton has caused them to be necessary witnesses at trial. Affiant intends to call as witnesses and cross-examine Judge Glanville, Lawyer Hilton, and Lawyer Love on how many other ex parte meetings the three of them and any other member of the prosecution's team have had. Judge Glanville cannot be judge and the witness in the same proceeding. Now still, yes, he's stretching the truth a little bit now. Because come on now, talk about Mr. Williams don't even really know Mr. Copeland. Still, please. Let's see. Lawyer Love and Judge Glanville, acting in concert, tell Attorney Bumpus that Mr. Copeland can cancel legal representation because Lawyer Love, Lawyer Hilton, and Judge Glanville have done everything to clear Mr. Copeland of judicial exposure. Without any reason to believe that Mr. Copeland might be fearful for his personal safety, Judge Glanville injects his safety concern as a hypothetical reason that Mr. Copeland would not testify. Lawyer Love, misrepresenting emails, continues the theme of Mr. Copeland's personal safety. There is no evidence of the same. Judge Glanville tells Attorney Bumpus that Mr. Copeland has to give testimony, though I mean that he has to do. Mr. Copeland got to give the testimony, whatever it is, good, bad, or indifferent. The question must be asked, why does Mr. Copeland have to give testimony? Is it because it favors the prosecution? Whose vantage point does Judge Glanville view this trial, good, bad, or indifferent to position? Judge Glanville must be recused. The court reporter announced off the record, Mr. Williams intends to call at trial Lawyer Love, and Judge Glanville to determine what was discussed during this off-the-record time period. Judge Glanville has the audacity to bring sworn witness Copeland into his chambers without the request of Attorney Bumpus, but at the request of Lawyer Love. From 9:34 a.m. until 10:03 a.m., nothing is recorded by the court reporter. Affiant will call Lawyer Love, Lawyer Hilton, and Judge Glanville to probe what occurred during this time period. Once in custody, represented by counsel, sworn witness Mr. Copeland is brought involuntarily into Judge Glanville's chamber. Judge Glanville explains, "I just wanted to bring you over and let you talk with Attorney Bumpus and see if there is anything that you need to ask of your counsel or Ms. Hilton or the state or the court before we bring you out this morning, because we would like to hear your testimony. And it is kind of where we are at this point in time. It is hard to articulate how wrong this ex parte summit is and how obvious it is that Judge Glanville discarded the sanctity of the judiciary to become part of the prosecution team. Judge Glanville is biased, and this case is constitutionally broken because of the conduct of Lawyer Love, Lawyer Hilton, and another member of their team." Judge Glanville. Why is Judge Glanville inviting Mr. Copeland, a represented party, to ask questions of Lawyer Hilton or other members of the district attorney's office of Fulton County or the court? This is beyond comprehension of an impartial, seasoned jurist to act. This is because Judge Glanville is not acting as an impartial, seasoned jurist, but is part of the prosecution team and must be recused. Lawyer Hilton makes it clear that Mr. Copeland has never stated that he has a safety concern which is stopping him from testifying. Hence, this whole safety concern discussed earlier was totally fabricated by Judge Glanville and Lawyer Love. Yeah, they might as well go ahead and dismiss this case. Judge Glanville, wait, did I miss that? Oh, Mr. Copeland states, "I have never been truthful a day in my life until I just made this statement right now." Evidence, Judge Glanville never uttered a word, nor did Lawyer Hilton or any member of the Fulton County District Attorney's Office provide the defense notice as this Brady evidence, saying as unconscionable, Affiant intends to call Judge Glanville as a witness at trial, as well as Lawyer Hilton, to discuss the failure to reveal this information to Affiant and for the jurors to be able to understand. The jury has a right to know that when a judge reads the instruction that the court has no interest in this case except for a fair trial, same is not truthful, as Judge Glanville is on the prosecution team. Oh, I'm not going through all these 233 pages. I hope y'all know that. Just gonna put that in the air. Just trying to see. Okay, this is the part I wanted to get to. Lawyer Hilton gives inaccurate legal information on whether Mr. Copeland can be prosecuted at all and gives some far-fetched ideas about the federal statute of limitations and the state of Georgia statute of limitations. Judge Glanville sits idly by and allows Lawyer Hilton to misrepresent to sworn witness Mr. Copeland that he cannot be prosecuted for these crimes. Anyone with a modest interest in this case would know that the prosecution has called Mr. Copeland an unindicted co-conspirator and that the supposed conspiracy statute of limitations continues today. Thus, Mr. Copeland could be prosecuted both in federal court and in the state of Georgia for crimes. This is wholly contrary to what Lawyer Hilton and Judge Glanville allow Mr. Copeland to believe. So see, that's the part I wanted to know, because that didn't even sound right, saying that it's past 5 years, so he can't be prosecuted for those crimes. Like, she definitely screwed herself over with that. It says, moreover, lawyer Hilton and Judge Glanville do not disclose other Brady versus Maryland super evidence, as lawyer Hilton explains that the state can assist Mr. Copeland with finding different places to live. Says lawyer Hilton then tells Mr. Copeland, who at that time was a represented person, that he can speak with her without attorney Bumpus present. Judge Glanville did nothing to stop this potential unethical conduct. Lawyer Hilton again tells Mr. Copeland that he is immune. What is that? Immunized? I got it. Look, I got it. I got to see if y'all be talking about me in this chat too when I be pronouncing words. Y'all talking about me? Would he try to get her to correct herself by asking his questions again? I did hear that part. Wait, they told him they can help him with other places to live. Yeah, she did say that. She said we talked. I can't remember exactly in the transcript, but she said, yeah, because you know I can't see. She said, haven't we talked about helping you find somewhere to live or something like that? She did say that in the transcript. While Judge Glanville sits silent. That statement is not true, as Mr. Copeland received only use immunity. However, Judge Glanville reinforces lawyer Hilton's wrong information because Judge Glanville is a part of the prosecution team. Judge Glanville tells Mr. Copeland that he will not be prosecuted for any crime. Judge Glanville and lawyer Hilton are acting as one, not separate as required by law. It's getting a little shaky, Sierra. Let me get me some water. D, see you starting your shit, D. You know that's a big word around these YouTube streets. Let's see. I'm trying to just read the important parts. Because we done went through that damn transcript already. Come on, Sierra. You know what? I hope you're not at work. I'm going to drop the link so Sierra can read the rest. So go and tell them you need to clock out. Go ahead and log out for me for the day. Oh, you said go to page 231? Okay. If I can do it like that. Ooh. I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that when you were questioning him. I also spoke with Don Jerry extensively about Mr. Copeland when he was assigned to this case, and I spoke with Ms. Love early in the process around the time jury selection was beginning. I have a plea with Judge Carsonal tomorrow at 9 o'clock, and I will come to the courtroom as soon as I am done. John. Good afternoon. I hope all is well. In our conversation with Mr. Copeland, he advised that you were not his attorney and he had not spoken with you. However, if you are asserting that you are his attorney, we will cease communication. But your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we were planning to pick him. So please make sure that he is present, so we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. Well. Hold on. Before I want to get down to all these exhibits, I want just to make sure. Because Because I'm not going through all that. I'm just letting y'all know that right now. This ain't that, Bookie. Oh, this is a transcript. Hold on, let me just make sure before we get to these different exhibits. What is that exhibit? Okay. Exhibit B is a transcript. What is this? Oh, that's a contempt of court. I want to know how they got it in the transcript about his notes. No, 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 no. Don't touch my notes. You'll clock out, Sierra. Okay. You have to put in work. Chop. Yeah, okay. I'm going to put in work, all right. What is this? Oh, that's the notice of appeal. That's for his bond. Order of contempt and incarceration. Exhibit E. God dang, how many exhibits he got? Okay. Let's see what's next. Good afternoon. He sent this June 6, 2024. It has come to my attention that the Fulton County District Attorney has questioned my client, Kenneth Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. And that is it. We are done. We are done. Most of that was just the transcript and different exhibits of the different motions we have already seen and went over. Let's see. Okay.
Bro, you finna stop leaving me on. You and Top are finna stop leaving me backstage for an hour and shit. What's wrong with y'all ass? Nigga?
I didn't know you was down there waiting. Just no. Just
Bro,
calm down.
y'all be dropping the link and disappearing. Give me my goddamn notes. The hell?
Let's keep it professional. So how y'all feel about this motion? How you feel about it, D? You think this gonna be what take them out of there?
In the arms of an angel.
You know what? I ain't
Of course, they added her after this. He ain't put all that shit in. He didn't type all that shit for no reason.
And you can tell he was progressively getting pissed off while he was typing that doggone motion. I'm talking about he was steady calling them hoes. He was calling them actors. He was talking all type of shit. I'm trying to see. I gave up. I just need to watch it all over. Lord, you know what? I'm feeling like some folks on YouTube. My doggone chat ain't worth nothing. Oh, they got Cat Not Williams. No, everybody must be watching it. Well, not watching it, but reading the thing. No. When he called Kayla honorable, I knew it was bad. Tell Kayla to add me up. I ain't say, oh, there you go. I see you, Tasha.
D, what's the claim number?
Bro, you don't shut your ass up. Keep this professional. I am
Good
not in the
morning.
damn transcript.
Good morning, y'all. Well, good afternoon, y'all.
No, it's still morning here.
It's afternoon. It's 12:44 here.
Yeah, it's 12:44 here.
No, I got 16 minutes.
That is insane. That is the longest motion I've ever seen in my life.
Listen, y'all. I think this is the end of the case.
I think so too. Because they can't go back on that. Like,
Well, really, the judge won't go back and treat Steele for after hearing all that.
When he said Honorable Kayla Bumpus and then said Lawyer Hilton and Lawyer Love,
bruh.
I screamed.
And then do you know how much disrespect is to call a judge, not only a judge, but the chief judge, a lawyer, even though he is a lawyer, but you done demoted that man quick.
To a part of the prosecution team.
But he sat here, he did it to himself. And I think Hilton knew, like, okay, yeah, we done messed up, because you can just tell her, like when she was just sitting there, you could just tell she was like, okay, we definitely done messed up. Still had time.
He worked with purpose.
Yeah, he had time to write that motion. He took his time for sure. The man said, no. Don't take my notes. So now I want to see what's, because now with him writing that motion, because that was the motion also to recuse the Judge Krause lady. I don't know if that's a lady or I guess is it a lady?
She's a lady, yeah.
To recuse her. Now it's like, I know she probably feeling like, oh, I'm not getting in this mess. The state need 48 more hours to respond. Right. After they see that, baby, they might as well just go and say, yeah, we agree. Go on, take them off the case. Disqualify us too. Nurse, his accent be killing me. Yeah, y'all know D got that Memphis accent. Her. Let's see, I wanted to see this part when, what day was that? Day 88? When they that morning he came back locked up.
That was day 89.
Day 89.
88.
They try to get that man a doggone coat. He talking about, y'all want him to see how y'all do me?
They need to mistrial them boys. Tell them folks, get them folks a bond. Tell them they gonna try them again in 2 years or something.
But I wouldn't even say mistrial though.
Why not?
Just dismiss it altogether.
No, that's too much. They ain't gonna. They pride in a way.
Even with their pride in the way, their pride just went out the door after that motion. Because even if they try to retry this case, it's gonna have too much stank on it. Like, ain't nobody gonna want to sit. I'm weak. They're talking about 2 years. They're talking about you in the chat. I don't know why Sierra wanted to come in today with that mess. She done been missing for the past week.
Tell her to get her noodles and water drinking ass on. And those better be going to unthaw that damn salmon.
I think it'll be a mistrial on behalf of the state and judge, and it won't be able to be retried. My bad, nurse. But yeah, it definitely need to be dismissed with prejudice. Like, don't leave these folks alone, because it goes to show that not only the judge and these prosecutors, like the whole DA's office, because they can walk down with how they was how what was it? Investigator Hamilton was trying to get with old girl.
Mm-hmm. No, it was what was his name? Yeah, it was his name, Hamilton.
I think it was Hamilton.
Something like that.
Oh,
I
yeah.
forgot about my boy. They need to make him show up.
Right, because why they ain't sat here and did nothing with him?
His little freaky ass. Trying to get the son a job and some more shit.
I'm trying to see when he came in.
Hamilton. Ryan down Hamilton. Yeah, it should be over after this. And then they keep alluding to, well, I don't know. Why the state keep telling Woody he can't talk? If they thought the case was gonna be over, you know what I'm saying, it'd be that. They still calling him, making sure he don't talk.
Hold on, I'm trying to see because I wanted to see. Because after they held Brian Steele in contempt that day, did they still have Copeland on the stand?
Mm-hmm.
I couldn't remember. I'm trying to see. I don't know where it started.
It's day 89.
My eyes, day 88 when he in his what's her face.
When he in his
Fulton
Oh
County.
yeah, okay. Yeah, you're right.
Because I know they got him on the stand. And then he wasn't even on there long, I don't think. At this point, I'm sure they have told Kayla. You know they had to tell Kayla to stop talking because that's what I was gonna say. When we had watched that video and Love was going in about who has, the interest of Copeland and everything else, you don't think she's gonna take all these interviews where this girl is talking about how she's this man's nephew godmom and say that they were working hand in hand? Like Love was already trying to give that off. And that's it. They're going to use that same exact thing to try to play a dirty game to do it. I'm trying to see. Let's see. I'm trying to find it. I can't. I give up. But yeah, I'm surprised I ain't see Kayla say nothing today. That she is mute. What a legend, Judge. You got 5 minutes to tell me who your source is. That day, when all this happened, we was literally sitting there watching this shit for 10 hours, y'all. Okay, here you go. Let's see if I
All right, Mr. Brown, Mr. Uhalski, Mr. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. Ladies and gentlemen, jury, good morning. Good morning. All right, we're going to go ahead and continue with Mr. Copeland here. So go ahead, Ms. Hilton.
Thank you, Your Honor. Mr. Copeland, good afternoon. Good afternoon.
I got said back.
You don't have to say anything. On Friday, when we left, I asked
Miss
you
this
how
little
old you
crybaby
are.
stuff
You
walking
said
with
you
me,
were
so I
grown.
gotta say it back.
Can you please tell me how old you are?
Say that again.
Sure. Can you please tell the jury how old you are
Look at a judge looking at him.
32.
Hold
and
on.
when is your birthday?
Say that again.
When is your birthday?
32. I never remember him answering that.
When is your birthday?
Next month.
Is that July?
I want to go back real quick. Because just look how the judge is like staring him down.
I got said back.
You don't have to say anything yet. On Friday, when we left, I asked you how old you are. You said that you were grown. Can you please tell me how old you are?
Say that again.
Sure. Can you please tell the jury how old you are in numbers?
Sure.
32.
Sure.
And when is your birthday?
Say that again.
When is your birthday? I'm sorry. When is your birthday?
Next month.
Is that July?
I think so.
Okay. And are we born on July 25th?
I guess.
Okay. Are you from Atlanta?
I'm from Candyville.
Okay. Is that a section of the city in Atlanta?
I guess.
Yes. All right. And did you grow up in Mechanicsville?
For sure.
Did you say for sure? All right. And when you grew up, do you have siblings?
Huh?
Do you have brothers and sisters?
Yeah.
All right. And when you were younger, did you live with all of your brothers and sisters?
Overruled, sir.
What does his siblings have to do with this case?
Absolutely nothing. Says the case that the state cited that still was a lawyer on was Muhammad versus state of Georgia. I think this was a Phonics case. Hold on, y'all. I'm about to bring it up. I don't see where it say Steele's name though. If this is the right case. It says, well, Bree at? Bree still in here? I'm trying to see if it's the right case. I expected more from you. Last video is so inaccurate and wrong. Anyways. But it says on May 21st, Muhammad was indicted for malice murder, 2 counts of felony murder, aggravated assault, and aggravated battery as the underlying offenses. Aggravated assault. On May 6, 2008, was sentenced to life in prison without a possibility. So what was this? Were they saying this was overturned and still was working on it? Because I can't remember that part.
Still worked on the appeal in this case.
Okay, let me try to find the appeal. Hold on.
The other one.
Okay. How many?
I think 3.
All right. And what are your 3 brothers' names?
Overruled, sir.
Trey Nato boss.
Say that one more time. You said it fast.
Nato Trey's boss.
Nato, Trez, and Boss. Okay. Nato, what's Nato's given name?
First off, I'm not giving you that.
You just give me the first name.
I just did.
Nato.
Oh, yeah. D, you can
Okay. Trez. What's Trez's first name?
tonight we can go over this transcript case for the one they tried to state, not knowing that Steele was a doggone attorney on it.
Trez.
Is Trez's first name Ron Trez?
I guess.
All right. And Nato, is that Rodney?
I guess.
Okay. And then what's the third nickname you gave me?
Boss.
Is Boss Rodriguez?
I guess.
All right. And when you were younger, did you go to school?
Yes.
Where did you attend school?
I don't know. I went to a lot of different schools.
Okay. What are all the schools you went to?
I don't recall all of them.
Oh, just tell me some of them.
I only know one. Slater.
Slater. Is that elementary school or middle school?
Elementary.
Why you don't remember what middle school you went to? Did you?
It's from that whole day. I'm sorry, I gotta find it. Hold on.
Let's go through your customary nightly admonitions. Okay, remember, as you leave here today, don't remember to leave your notepads in the basket.
Woody definitely can. Woody really can talk about it because they never told him not to say nothing outside of court. They just let him leave.
Yeah,
Copeland.
they did.
Sir, over here. Over here. It's me. The state has filed an order of request asking that you be relieved of your custodial portion of this particular contempt on the condition that you just continue to come back and give your testimony, okay? So I will release you from the custodial portion as long as you come back tomorrow morning. Fair enough? If you're not willing to do that, I'm gonna leave you where you are. So the choice is yours, sir. The state's asked me to sign the order saying, hey, if you'll come back tomorrow morning, all I want to know is if that's the case.
I'll be back.
All right, 9:30 tomorrow morning, okay?
All right.
All right. All right, we can let Mr. Copeland be released and processed. Say again? Yes.
I'm weak, man. Y'all excuse me when I get out.
I'll get it. Sergeant Green, old fat jelly roll neck ass.
Big Nick bastard.
Don't do damn Steele like that. Got Steele fucked up.
Man, meatloaf Nick ass. No.
My notes.
He might have went up there and tried to snatch the notes to see what it said.
Did they have? That's what I was gonna look at the transcript. I wonder how did she actually put that down? Because you know, Love was telling her not to. Big back bitch.
You all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again? Respectfully, I will not. I cannot. Sir, you have to. Well,
You're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Look mad as hell.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of.
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for the next 5 minutes.
Yeah, y'all done literally made me read for 2 hours straight. He's going live tonight on his page, right?
Yeah. I don't know about all that. We'll see.
Why you can't go live on your page?
I didn't say I can't. I just said we'll see.
Oh, never mind. D gonna be busy.
What do you mean we'll see?
Because if y'all sleep, shit ain't going on there.
We gonna be up.
No, I'm gonna check. That's why I said we'll see.
I didn't know if y'all was gonna be asleep this morning, but it dropped, so we had to get on it.
We'll see if everybody's still fucking up.
Well, I can't go live again.
Oh yeah.
What?
How's that, Tasha?
Why?
Huh? I have to wait a few days.
What you did?
Huh?
What you did?
I didn't do anything. I'm just gonna I'm gonna rebrand myself. I don't want to seem consumed. So if I go live today, I'm gonna want to be petty, and I can't. I made a promise.
Thank y'all. See, Sierra gave me an A for my reading. I only missed 2 words.
Y'all is retarded.
Yeah. I'm not gonna I'm not gonna lie. One of those words, it was a little shaky, but I wouldn't have got it either. So I was rooting you on. I was rooting you on. It was D that was not present this morning.
D, you was not you. Now she ain't lied, D. You was late to the party.
I was knocked out. But I was like 5 minutes late. Shut up.
Listen, I know that we all don't have our own lanes and we're all trying to figure this YouTube thing out and we're stealing from people, but I appreciate you guys for getting on live and getting KD for paying for that document.
I didn't pay for your document.
You didn't?
No, Bree got it for us. Shout out to Bree. Bree always come through with the documents. Thank
Oh
you.
my God, Bree, come on. Like, listen, I don't know what field Bree work in, but if she is not, she should be in some type of private
Bree
investigative
come
field.
through with every last one of those documents for us. So shout out to Bree. But if we all up, we can go live tonight. Maybe pull some of those transcripts.
All right.
I don't know if we can
Sierra, I'm
pull
gonna
the
come get some
transcript
noodles.
currently.
Yeah, Sierra, we about to send you some noodles. You like which one you like? Chicken, beef,
Or shrimp.
or shrimp? Which one?
Oh my God, y'all listen. I like chicken, but you can also get the ramen noodles from the Chinese store, and they're really good. The spicy habanero. If you haven't had those here, those are a little fancy. They got like little meat packets and stuff that you can put in there.
Now we're talking about noodles.
No, we trying to get spicy with it.
Yeah.
Me.
All right, I'll see y'all in the cut.
Right, we're going to the cut now.
It was nice seeing you, Sierra. I'll donate to your noodle fund. Cody.
Bye, y'all.
Y'all enjoy y'all afternoon.